Today's topics, I'm going to cover 5 topics. What are VA benefits? Who's eligible for VA benefits? An overview of VA claims procedures, and an overview of VA disability compensation, and what do you need to do in order to represent a veteran before the VA. The first section, what are VA benefits? The Veterans Administration, first of all, is the second largest department of the federal government after the Department of Defense. And the VA is divided into 3 branches: the Veterans Health Administration, that's the hospital side; Veterans Benefits Administration, that's what we're going to talk about today; and National Cemetery Administration. So today we're going to look at VA benefits administered by the VBA. What are VA benefits? They're issued through the Veterans Benefits Administration branch of the VA. Disability compensation, pension, survivor's benefits, and other, including GI Bill and home loan, which are important. Okay, disability compensation, which is what we're going to talk about in more detail. VA disability compensation provides monthly payments for service-connected disabilities based upon ratings of severity of impairment. We'll focus on VA disability compensation in a second. Survivor benefits. In addition to VA disability compensation, the VBA administers survivor benefits, including dependency and indemnity compensation, a monthly benefit to surviving spouses or dependent children of veterans whose death was substantially contributed to by a service-connected cause, or if the veteran was rated 100% for at least 10 years prior to death. It's like a survivor annuity. It's the only major benefit that survives the death of the veteran, so it's important. VA pension. VA pension provides a small veterans pension that can be critical to qualifying older veterans who do not have other retirement resources or have substantial long-term care and medical bills. Pension is a needs-based program. It requires wartime service, at least 1 day, low income, you've got to be over 65, or total and permanent disability. Does not need to be service-connected. Service-connected is an important part of the main topic of disability compensation. It's similar to SSI. There's an offset. So until you are in a nursing home getting both Social Security and VA pension and having a lot of that drained off by medical expenses, VA pension may or may not be helpful. Most of our veterans, it's not that helpful, even though they're very low income. GI Bill, VRNE, home loans, etc. GI Bill benefits and home loan are important veterans benefits. Veteran Readiness and Employment, VRNE, formerly known as VOC Rehab, provides funding for job training for disabled veterans. These are really important, but not the topic today. Who is eligible for VA benefits? A person who served in the active military, naval, or air service and who was discharged or released therefrom under conditions other than dishonorable, and that's an important concept. A veteran must establish eligibility in order to receive benefits. A veteran must have served on active duty in one of the 6 branches of the Armed Forces of the United States. Yes, there are 6 now with the Space Force. If in National Guard, the injury, disease, or condition must have occurred while activated by the federal government, not by the state government, to be eligible. National Guard is a dual employer, so if you're California Army National Guard, when you're on state duty, you're employed by the state. When you're on activated federal duty, you're active duty just like the regular Army. If a reservist, same concept, injury, disease, or condition must have occurred while on active duty or active duty for training. By the way, active duty for training counts for both of those for being on active duty. A minimum duty requirement. How long? Most veterans who enlisted after September 7th of 1980 or entered active duty after October 16th of 1981 must have served 24 months or the full period for which they are called to active duty to establish basic eligibility. However, this minimum duty requirement may not apply to veterans who were discharged for a disability incurred or aggravated in service, or were discharged for a hardship or received an early out. So there's exceptions. Disability compensation benefits are available if a disability was incurred in or manifested during service or was aggravated by service regardless of the period of service. If service was honorable for VA purposes or other than dishonorable. What does that mean? When a service member leaves the military, they will wind up with a characterization of their service for that enlistment period. Honorable, general under honorable conditions, or uncharacterized if it's like a boot camp, a short-term enlistment cut short. So those would all be considered honorable for VA purposes. Then there's other than dishonorable or undesirable, that used to be called undesirable, other than honorable, OTH, bad conduct, discharge, or dishonorable. Bad conduct discharge is usually issued following a special court-martial, and a dishonorable be after a general court-martial. The VA will develop for character of service when eligibility is in doubt. GI Bill education benefits require a qualifying, fully honorable term of service. Even a general under honorable conditions will not qualify you for GI Bill eligibility. Other VA benefits require that the service during the relevant period was other than dishonorable, or as we say, honorable for VA purposes. Overlapping enlistment and re-enlistment periods can result in eligibility issues. Sometimes we'll talk about a DD-214 in a second, but that's I'll go forward to it. So when a service member is separated from the military, they receive a DD-214 certificate of discharge or release or discharge from active duty, and this will include the character of service. It will show it. Sometimes more than one enlistment period is covered in a certificate of in a DD-214. So it's the VA has to determine whether it is more than one enlistment period, because, go back, if you have the overlapping enlistment periods, you might actually qualify for VA benefits because you have one honorable term of service and one term of service that's not. Parse it further that if you got your disability during a dishonorable term of service, that's another level of problem. So you can see this area can be a hotbed. If you are ineligible for VA benefits, you can either try to find one of the exceptions to apply, and the VA just changed statutes and regulations around character of discharge to make it a little bit easier, not as much as veterans advocates wanted. There's a little broader breadth to the compelling circumstances exception, where if you can show that there were compelling circumstances that resulted in the misconduct for which somebody received an other than honorable or even a bad conduct discharge, you may be able to still have them be eligible for VA benefits. And if they were insane for VA purposes, which is not a medical term, it's more like old school insanity. Nobody calls anybody insane in mental health anymore, but the VA does. And again, there's a whole sub niche, but just to be aware of it, because you can do the research if it seems to apply. I've got one pending right now for a veteran who's hospitalized at Patton State Hospital with schizophrenia, and we're trying to show that he had that manifested during his Navy service, and that in fact he should have his VA benefits, and that he should be considered disabled for VA purposes. Okay, so the other way, if you can't get there through the VA process, you've got a discharge upgrade process, which we saw the video about. That's a whole different process through each military service department has discharge review boards and boards for correction of military records that you can apply before to see if you can get an upgrade of the discharge that will actually correct the military record of the veteran. The VA disability, we're going to really be focusing on the VA disability compensation procedure, but these general procedures apply different initial application to the other benefit areas that we were talking about. So a new claim, you file a VA form 21526. By the way, VA loves forms. They love forms. And in fact, sometimes they don't know which form you should file, but they're going to tell you, because if you file a new claim form and they think you should have filed a supplemental claim form, they'll send you a form letter telling you filed the wrong form. If you file the supplemental claim form and they think you should have filed the new claim form, they'll send you the same form letter. And so if you file multiple claims, if you filed supplemental claims and new claims at the same time, you may get a letter that you can't tell which claim they're talking about. So it's always one size fits all, but they don't know which size they would like you to have. So it depends on who actually says it. And I mean, you can fight with them for months, and sometimes it's better you file both, a new claim and a supplemental claim form, and then they're going to tell you you're going to get, you're going to get a form letter, because they're going to tell you one was wrong, but they're going to continue processing the other one. In theory, a new claim form is if you've never filed a claim before, or if you're seeking a rating increase for a claim that's already been granted. Okay. The Appeal Modernization Act, which came in 2019, simplified in a lot of ways things, and it's really the only one that I've worked under, so I don't know if it's better or worse. There's some of the old guard are still arguing about which is better. So when an initial claim is denied, a veteran can continue to pursue the claim by, one, filing a supplemental claim that requires new and relevant evidence. If you've got new and relevant evidence, file a supplemental claim. If the VA made a mistake based on the existing evidence, you can file a request for a higher level review, which is an expedited review by an experienced VA regional office employee. Or you can file an appeal with the Board of Veterans Appeals, which is an appeal heard by an actual administrative law judge. The key is you have to file within 1 year of the denial to keep the claim open. And you can kind of daisy chain by having a filing that's legitimate and having a denial and coming up with either new evidence or argument and continuing. And at some point, you may actually have done 3 filings, and then you finally get your claim granted, and then your effective date can be all the way back to the first filing. And that's one of the things that we always try to keep in mind as we're going along. It's not like most of our legal deadlines, and whether it's civil practice or wherever you're filing in any court, these deadlines are typically way longer. The only issue is when a veteran comes in and says, "Oh yeah, I might want to file something," and they come and ask us for help, and it's like 3 days away from the time they need to file. It's a little more challenging. And then the pro tip is filing an intent to file, which is a VA, another form, VA form 210966, which saves the date of the filing of the effective date of the claim. It's intended to allow veterans a chance to develop their claims when they're going through the whole process of, you got to gather evidence and medical information and submit a personal statement. So the first thing you can do is file this intent to file, and then if it takes you 6 months to get all your stuff together and file it with the VA, when the VA ultimately decides the case another 6 months to a year later, it's going to relate all the way back to the intent to file date. And you have a year from the filing of your intent to file to go back and to file your actual papers. So it can really save a lot of time, and it's one of the first things we look at. The only challenge is if you're getting into the case in the first instance, you file an intent to file, you haven't even seen the VA claims file, you may, if there's already one pending, you can only have one pending at a time. So you got to double check and make sure that that you have an active intent to file, because you might have one that's already on there and you're coming down to the wire on the 1 year of the active intent to file. Appeal Modernization Act, 3 lanes after denial. We've covered this. Supplemental claim. File that if you have new and relevant evidence. Higher level review. VA made a mistake, particularly if it's obvious, file the request for higher level review. You get somebody who's more senior who reviews it, and you have to, it's about 4 months. BVA appeal takes about 2 years, and it requires a lot more in terms of what you're going to submit. So filing to the BVA is kind of at least in our world where we're dealing with caseloads of over 100 veterans, that's a lot of time commitment for us. So we try to cycle through the higher level review, and you go 4 months, and one of the great things is you get an informal telephone conference, and you have the person who's just looked at the file, and sometimes they say, oh, I see exactly what's going on. Sometimes they say, tell me, it's either the hot bench or the cold bench. It's tell me what I need to know about this veteran. And so then you have to go through the whole song and dance. But sometimes it's as simple as oh, this is a mistake. We have a lot of people who don't know what they're doing. We need to fix this. It's like, good. Well, I'm glad for the result, but why did I have to do 3 times the amount of work to get to this point? And anyway, so it's a broken system. Even those who are working in it acknowledge it. Supplemental claim, new and relevant evidence, what could that be? Medical evidence is quite typical. Buddy statements regarding an in-service incident, and again, file within 1 year of the denial to keep the claim open. Higher level review, we talked about this. Senior level reviewer takes a new look at a case to determine whether the decision can be changed based upon a difference of opinion or an error. The Board of Veterans' Appeals, one important point is there's a request, you can request a hearing and opportunity to submit additional evidence, or you can request a board review without any additional evidence or hearing, which is obviously, it's faster. And if you ultimately disagree with the decision of the board, there are several motions that you can make, or you can appeal to the Court of Appeals for Veterans Claims. Court of Appeals for Veterans Claims, which has exclusive jurisdiction over the BVA. They used to have, for BVA, they would like ride circuit. I think now it's not done at all. So you could like schedule a hearing when they were in town kind of thing, but I don't believe that they do that at all anymore. And because you could, there's no Zoom or... Well, I think that's what they've gone to. I think we're not currently doing BVA or CAVC. We're just, our volume of the lower level stuff is so high. That's probably a 2026 to get back to that. Retroactive benefits and effective dates of claims. We talked a little bit about this, but if you keep the claim live, then if a veteran files a supplemental claim for the same benefits that were previously denied by the VA more than a year prior, and the supplemental claim is granted, the effective date will likely be the date of filing of the supplemental claim or date the benefit arose, whichever is last. So you don't get to reach all the way back. However, if the veteran files a supplemental claim, but does so within 1 year or less after the date of the prior denial, whether the denial was by the regional office, on a higher level review, BVA or CAVC, the effective date will be the date VA received the claim that preceded the supplemental claim. Like I say, it can be daisy chain back, so it could be quite a while back. So it's important, this concept of continuously pursuing a claim is an important concept to bear in mind anytime you're working on a veteran's claim. We're on to Section 4, an overview of VA disability compensation. For disability resulting from personal injury suffered or disease contracted in line of duty, or for aggravation of a pre-existing injury suffered or disease contracted in the line of duty in the active military, naval, air, or space service, the United States will pay to any veteran thus disabled and who is discharged or released under conditions other than dishonorable from the period of service in which said injury or disease was incurred or pre-existing injury or disease was aggravated, compensation as provided in this subchapter. So that's it in a nutshell. It's always good, as lawyers, we want to go, okay, where's the law? Let me see the law. Okay, that's the law. Disability compensation. There are 3 specific elements that need to be satisfied before a veteran may be awarded VA disability compensation. Got to have a current disabling physical or mental condition. Condition must have been incurred in, first manifested in, or have been aggravated during military service. In-service incident. The veteran must show a nexus, a connection between the current condition and in-service event, injury, or illness. So a veteran must have a current physical or mental condition. Preferred proof is current medical diagnosis documented by a competent medical professional. Non-VA diagnosis is admissible in most circumstances. Credibility is important. Veterans without a diagnosis may still apply, but must include a declaration, a statement, a personal statement that articulates their current symptoms in order to obtain a free VA compensation and pension C&P exam and an examination by an outside contracting health professional in the appropriate field. All sorts of stories about what's an appropriate health professional. VA has contractors who will provide those exams. Competent evidence of a current diagnosis. So obviously current medical or mental health treatment records, VA disability benefits questionnaire. That's, you can have a private physician submit one of these. There's a lot of VA forms for these disability benefits questionnaires, but typically this is the VA contractors submit those. The veteran signed statement counts. It's not, we're in below the level of administrative law in terms of evidence. This is supposed to be a veteran-friendly system, so the veteran can write a handwritten statement, and it doesn't have to be in any particular form. They want it to be on their VA Form 214138, which is a statement in support of claim. But if the veteran submits a handwritten, scratchy statement, they're going to consider it. In-service incident, an event, trauma, injuries. When were the initial symptoms? What was an initial diagnosis? A condition was incurred or aggravated during military service, or a condition which was incurred during a qualifying presumptive period after active duty. As we'll see, there's some presumptives that there is no time limit on when the diseases can manifest after service. Competent evidence of in-service incident, service treatment records, official military personnel file, competent lay evidence. Again, you can have buddy statements that the VA will take into account. An example would be veteran has sleep apnea. Wife who was married to him during service submits a buddy statement saying, yeah, he was always, waking up in the middle of the night, gasping for air. Or on deployment, and actually had this, somebody he bunked with said, yeah, I thought he was going to die because he was always, middle of the night, he'd be gasping, stop breathing and gasping. And so that gets it back to and then you show the current condition, and there's a connection. So the veteran must show a nexus, a link between the current condition and in-service incident. You can get a nexus opinion from a medical examiner. You can provide that. The C&P examination by the contract examiner from the VA, they will get that disability benefits questionnaire, but there's a second document they'll often ask for, which is a medical opinion disability benefits questionnaire, which will specifically answer whether that health professional thinks that there is at least as likely as not that which is the standard, at least as likely as not that the injury or illness was related to the service. Okay, so we have 5 theories of service connection. We're going to race through them. Direct service connection, aggravation, secondary service connection, presumptive, or VA medical care. We're going to ignore the VA medical care because that's all about malpractice. We don't go there. Really, you want a medical mal attorney to handle those. Direct service connection. Basic premise, veteran must show their current disability is directly linked to the in-service incident. The greatest challenge is proving chronicity, i.e. the continuity of symptomatology. The veteran injured his back during a car accident while en route to weekend drills in the National Guard. He's hospitalized. Veteran was a Navy medic in Iraq who injured his back carrying wounded Marines but never reported it, self-medicated, and was homeless and without health care post-service. There's going to be challenges. Secondary service connection. Basic premise. Any disability that is caused or aggravated by an already service-connected condition can be compensable. The greatest challenge, proving that the service-connected condition, at least as likely as not, caused or aggravated the new condition. You have a back injury, actually it's a knee injury or a hip injury that then causes a back injury. You have all those kinds of muscular skeletal issues. We have been successful several times with hypertension, which is one of the newer presumptives for Agent Orange. But hypertension can cause all kinds of other problems. So if you have high blood pressure for long enough, you can have conditions like aortic aneurysms and that kind of thing that wouldn't on their own be considered service-connected. Aggravation. The basic premise, veteran may be compensated for a disability that began before active duty but was made measurably worse than it would have been had the disability progressed naturally. The greatest challenge is proving military service aggravated the natural progression of the condition. This is particularly true with diseases where VA will often try to push back and say that the disease just progressed according to its natural progression. But we have, then it's the science is what you really need, right? The veteran entered the service with a minor left wrist problem, which significantly worsened after a car accident in service. I mean, those are kind of easier cases, although, again, aggravation is an area that you can get pushback on. Presumptive. Here's a hotbed. Basic idea, some conditions can be legally presumed to be service-connected. Congress decides what are presumptive conditions. Depend upon the type of disability and when and where the veteran served. Presumed exposure to Agent Orange if he served in Vietnam or the territorial waters, 1962 to 1975. Guam or American Samoa, 62 to 80. Some service in Thailand, Cambodia, Korea, and there's a list of illnesses presumed caused by Agent Orange or herbicide exposure. And then the PACT Act of 2022, we've probably all heard about this, burn pit diseases, presumptions, post-1990 and post-9/11, service in Southwest Asia, Iraq, Afghanistan, presumed to cause certain diseases due to exposure to toxins. Agent Orange exposure, qualifying service during presumptive period, set foot in Vietnam during a specified period, served in Vietnam's inland waterways, Blue Water Navy veterans, that's within 12 miles of the Vietnam, Republic of Vietnam coast, some service in Guam, Thailand, Korea, some service at domestic storage locations. Examples of qualifying conditions, diabetes mellitus type 2, prostate cancer, lung cancer, Parkinson's disease, ischemic heart disease or coronary artery disease, leukemias, and hypertension. The PACT Act of 2022 expands and extends eligibility for VA healthcare for veterans and also expands the benefits. There are 23 presumptive conditions for burn pits and other toxic exposures. There were 3 added. There were 20 in 2022 and 3 more were added in 2024. Adds more presumptive exposure locations for Agent Orange and radiation exposures. PACT Act scenario. An Army reservist deployed to Iraq for a year during Operation Iraqi Freedom. The kitchen where she worked was located next to a giant burn pit and trash was burned 24 hours a day, 7 days a week. This trash included building materials, batteries, paint, food waste, bodies, old military equipment, oil, etc. Upon return from Iraq, she has ongoing sinus problems with flare-ups that seem like really bad allergies, but she never had allergies before. She may have chronic rhinitis or sinusitis from exposure to burn pits during service. This may be presumptive under the PACT Act. Toxic exposure risk activity and direct service connection. So a blend of the idea of presumptive and direct service connection. When a veteran is seeking service connection for a disability due to toxic exposure, but the law does not provide for presumption of service connection for the claimed condition, a claimant is not precluded from establishing service connection with proof of direct causation. What does this mean? The VA adjudicators are required to follow direct service connection TERA procedures under which a VA examiner may find the claimed condition was at least as likely as not caused by indicated toxic exposure risk activity after considering the total potential exposure through all applicable military deployments of the veteran and the synergistic combined effect of all toxic exposure risk activities of the veteran. We've been successful in service connecting several veterans for diseases that are not on the official list because their toxic exposures have been determined to be at least as likely as not caused by their toxic exposure risk activity. About VA disability ratings. VA assigns the veteran a disability rating based on the severity of impairment of work and social functions caused by the service-connected condition. The effective date for payment may be the date of the original claim if continuously pursued. The VA uses total combined disability rating and number of dependents to determine how much disability compensation the veteran will receive each month, as well as eligibility for other VA benefits. The VA math, and veterans are both joke about, and it's kind of more dark humor about how does that VA math work, because it's not just a straight addition of you have a 20% rating and a 50% rating and another 50% rating and you're at 120. It's the rating you take, you get there by half more, like, because it's the amount of unallocated disability. So if you have a 40% disability rating, you have a remaining 60%. If you have a 30% disability rating, that's 30% of the 60%. So that's 18%. They do round up. They're very generous about that. So you would have the 40 and 18, it would be 58. That rounds up to 60, so it's 60%. It's not 40, and 30 is 70. And so you can see when you get to 90%, and this is where we get a lot of veterans coming to us and going, I've got 90% and I got all these 10% and I'm not at 100. How's that? It's that incremental, getting it there. So there is actually a fact that if you have enough 10%, they will roll you to the 100. So 100% ratings and more. If you get to 100%, VA may assign 100% combined rating or may grant 100% due to total disability due to individual unemployability. What does that mean? If your rating's at least 70% and you cannot gain or maintain substantial gainful employment due to service-connected disability. And what does that mean? Well, VA is very cute about this. They won't give a clear answer, but it's in all probability if you earn below the poverty line in your employment, or it's intermittent employment, like self-employment as a handyman. They're probably not going to come after the veteran. But you can lose your TDIU if you return to work and earn regular wages that are considered substantial gainful employment. And it does happen. VA does come back. So it's a scary proposition for veterans who have 100% based upon individual unemployability. And you think, well, if they're 100%, how could they work? But if you're 100%, and part of that 100% is because you got PTSD, sitting at home is probably not the best for your mental health. So if you can get out and do something, it would seem like it would be a fair thing to try to get veterans as engaged as they can be. 100% rating may be temporary. Okay, we have that all the time. You have a surgery or you have a first diagnosis of prostate cancer, you're going to get a temporary 100% rating, but as you get care and get that taken care of, you're going to get reduced. 100% rating may be or become permanent and total, and that depends upon reevaluations potentially, or when it's determined to be by VA to be static and permanent. And that results in extra benefits, dependents education benefits, free health care, state veterans benefits, special monthly compensation and aid and attendance, caregiver, or other benefits that are important but are beyond the scope of today's initial VA Benefits 101. Why should you be a VA-accredited attorney? Well, it's a great opportunity for life-changing service to our military veterans who served us. VA claims and appeals involve bite-sized claims development and drafting that values clear thinking and writing. Non-litigators and litigators are both welcome. New attorneys and senior attorneys will both benefit. VLI staff is available to mentor and support as you learn. It's a continuous learning experience, and I can say that I'm still learning a lot every day that builds subject matter expertise